Okay, we're live.
Hi, I'm Deborah Lucci from the Deborah Lucci team, William Ravis Realtors in Andover, Massachusetts, probably about 30 minutes outside north of Boston. And we're going to be talking about the situations that I haven't seen in a very, very long time. This is kind of new, rent back situations, and then also use and occupancies. And we have a team member here, Mackenzie Cormier, with us, and also attorney Libby. So, Libby, where are you located, and how long you've been? Tell us a little bit about you.
Sure. My office is in Salem, Massachusetts, and again, fairly close to Andover, just down 114. So I've been in practice since 2007. I worked in the legal field prior to that as well. Went to Suffolk Law School. So I've been working with your team, and it's been wonderful. Great team to work with.
We love
Always
you, Libby.
super organized. I never have to worry about where something is or what's going on. It's wonderful. So we've been really enjoying that. And we do the closings obviously up in Andover because that's where you're located. So it makes life easy for everyone. But yeah, we've had a really interesting market, and it really pays to have a good broker on your side on those. As your team is well aware, it's nice to have the experience behind a broker so that they can really properly advise their client, which has been nice to work with you folks on.
So we've encountered, I primarily list property, and we've encountered a very different situation where, because the inventory is so tight, sellers are, they're saying to me, geez, this is great that it's a seller's market, but I don't have anywhere to go. What can I do? I mean, so this new thing kind of, I haven't seen it so prevalent as I have now. Rent backs, use and occupancies. Let's talk a little bit about how the bank feels about it. Some advantages to the sellers, some maybe catastrophes. You've seen good things, bad things. So tell us a little bit about what you've experienced so far. And also, like when you're writing up an offer, I mean, when does this all come in? What do you advise on some of these things?
Sure. So it should be in the offer. You don't necessarily, I mean, it's nice to have it in a listing, but your sellers may not know at that time that they're necessarily needing that sort of accommodation. But if you're going to accept an offer, it should be in the accepted offer. It would be nice to have a level of detail in the offer, but oftentimes it's just, we'll see subject to suitable housing, or seller needs to, have a use and occupancy post closing. That will at least signal to your buyer that there's going to be a negotiation about that after the fact. And during the purchase and sale. And typically at that time, that's when a lot of the logistics happen. You figure out how long is the use and occupancy going to be post closing. Is there going to be a cost to the seller to stay over after closing? What things are they responsible for? Are they responsible for continuing utilities? Landscaping, who's responsible for what? And that's a conversation that should happen fairly early. A limiting factor for a lot of people, and certainly buyers coming in, is if they're actually getting a mortgage with the property, they have to take possession within 60 days of the closing date. So while a lot of buyers want to give a lot of time for sellers to accommodate and make their offer look better, in reality, they are restricted to that 60 days because they're typically buying it as a primary property, and they do need to, according to the lender, move in within that time period.
Now, have you seen anybody run over that? Like they have the intention of 60 days, but then something happens and it ends up being, yeah, of course. Yeah. 70, 80, 90.
Yeah, not personally. And what we do to ensure that does not, happen is what you'll see in any use and occupancy is, one, there'll be a holdback from the seller's proceeds, right? There'll be an agreed upon amount that's sort of set aside for just in case something happens. That, there's incentive to move when they're told to move. There's also a per diem incentive. So if they were to stay over the 60 days or 45 days, there's a very onerous amount that would come due. So it would be something like $300 a day. And that could be taken out of that escrowed amount that's held at closing. So we try to avoid those issues. but they can happen, and that's always a concern. And I think attorneys really don't love use and occupancies. We do them because we're told to, because people have agreed to do that. But it's, you really do have to be upfront with clients that things can go terribly wrong, and now you have someone living in your home that you've now paid for. And so we do try to make it very difficult on a seller if they stay over.
So tell us the difference. What's the difference between rent back, use and occupancy, lease? I mean, what is the difference with all these things?
Sure. So if you're a landlord and you have a tenant, you're going to go into a lease, or you'll be a tenant at will and not have a lease. That is a very particular relationship in Massachusetts, and it's defined very stringently. We're a very tenants' right state of
Mhm.
Massachusetts. So if you've ever, been a landlord, it can be very difficult to evict a tenant. We
Right.
very specifically call these use and occupancy agreements, and the person who is basically the buyer in the situation, if the seller is staying over, the buyer is a licensor. They are licensing the premises for the use of the seller. And we very particularly in the use and occupancy say this is not a rent. This is not a rental situation. This does not fall under an eviction situation. And again, we have provisions in there for if it becomes an issue where we have to essentially evict, even though it's not a landlord situation, where the fees get pulled out of the seller's side of things, because that's not what was contemplated in the agreement. But it very particularly is not a landlord tenant situation. We do call them licensor and licensee, and we very much exclude and put exclusionary language in the use and occupancy in order to be very clear that that's not the intent of the parties.
Now, this is fairly new. So, like, some of the questions I have would be like, when do the utilities get read? Typically they get read at the closing, and
Mhm.
now when do they get read? And then, the same thing with landscaping, cleaning. I mean, like, what is typically the seller? What are they responsible for, and what is like really the buyer responsible? And let's say the dishwasher lets loose after
Mhm.
the closing, and I mean things like this.
Right. And so that is where you see it's a little bit similar to a lease, where you say, okay, what is the status of the appliances, what gets replaced? There is a definition as to what happens there. And it's very dependent on the market, right? So who is empowered in the market is who is empowered in the negotiation of the use and occupancy. If you cannot get the property but for getting a use and occupancy with the seller or giving that out, then that seller really has the negotiating power. They're going to say, I don't want to have to pay anything, or, this is all on you after the closing. We just get to reside here for a little bit longer. And so I do find some are very, very broad. They don't really define anything. People are kind of, lackadaisical, and it's fine unless there's a problem. And so really, we tend to define who's having the insurance, right? So the homeowner's insurance will be taken over by the buyer. They are then the homeowner.
Really? So now, does the homeowner typically let their insurance go? They let
The
their
homeowner,
insurance
the
lapse?
homeowner will terminate, and they are then responsible for any sort of tenant insurance, essentially their stuff. So
Mhm.
they're not required to get that, but they cannot make a claim necessarily against the new homeowner's insurance, for any sort of damage. And that's usually explicitly stated. But because they're the homeowner, the buyer does have to create that insurance situation, even though the seller may not be allowed to make any sort of claim against it. There's often a lot of liability language, waiver of any liability for any guests of the seller, anything like that that happens on the buyer's time. Um, as well, and depending again on the people, shoveling, the daily items are typically the person who's living there, just like it might not, sort of be in a rental situation. And again, depending on who it is, they may say we want to take that on, or we have a plow guy we love, we're just going to keep it in place. It's worth it to them to do that. But I have had use and occupancies where there is no, I mean, there's consideration, but they're not paying a large monthly amount, and sellers have negotiated that as part of their their offer situation.
So
It's very beneficial.
are you seeing a lot of buyers, Libby, actually say that they're willing to pay for the monthly cost and that they're not going to be charging the seller anything at all?
I've had 2 of those in the last, I can't say it's a predominant thing that I'm seeing happen. And I think it depends on where you are purchasing.
Right.
As well, like, and the buyer situation, do they have an ability to stay where they are? Many buyers do not have that ability, so they end up really needing to be in there a lot earlier than the seller's comfortable with. So you really have to know your buyer and their ability to roll with the punches there and move in post closing. But I think David also mentioned what's the question about the condition of the property. You're still going to do that final walkthrough before closing, period. That needs to happen. You need to, at that point, say, okay, can we move forward with closing because is everything in the correct condition? But then you also have to establish what the condition is before the use and occupancy. And then you'll do essentially a second walkthrough when they terminate and they leave. And again, you can look to that escrow amount that's been held if there's been damage, if there's an appliance issue. And for instance, I had one where the dishwasher let go. And there wasn't, it wasn't a water issue, but it was a very nice dishwasher, right? And they got into it and they said, well, we shouldn't have to, a regular dishwasher would be, $500. And, my position was, we didn't have a regular dishwasher. We had a top of the line $1,000 dishwasher, and that's what needs to come out of it. Even though it was maybe 10 years old, the fact of the matter is it was a functioning, this type of dishwasher. It needs to be replaced with that type of dishwasher. And so, you do have those situations where you kind of have to fight about, what's an entitlement if there's an issue with a broken appliance, or, if there's an actual insurance issue independent of the seller.
So it sounds like almost like as an agent, when we're writing these things up and also as a listing agent accepting them, it's almost like we should make them like fairly vague, maybe, agree on some like buy, sell it to pay buyer so much a month, and then attorneys to work out use and occupancy, because it sounds like there's so many moving parts that have to be more black and white that,
Yes.
you probably have an agreement that, you feel comfortable with that hits a lot of these scenarios.
Right. And so typically what I would see is something to the effect of subject to mutually agree upon use and occupancy agreement for X amount of time and X amount of money. And that would be something that I would see in an offer. I wouldn't see much more detail than that.
Okay.
And that way, the little ins and outs can, excuse me,
Bless
be
you, Libby.
negotiated to that point. Excuse me. That would only happen once a day and during a live. Right. So, while people really want to get into the details, it's not appropriate in an offer situation. And typically people don't have counsel at that time. So they're not necessarily prepared to have that conversation or be thinking about those details at that time.
Okay. One of our team members, she encountered this. I haven't, when Candida closes, this will be my first one, all the way to the end. But one of my team members, they had a use and occupancy, and she was bringing in the buyers. And what happened is the place was not cleaned properly. And I don't think any escrow, it was early on, so there was no escrow money held back. So we're finding out some of these things that have happened. Like, so what are some of the good and bad things that you've kind of seen out of these?
Well, I think they really do cause an offer to look a lot better, right? So if you as an agent have spoken with a listing agent and this is super important for the sellers, getting that in your offer is going to really make it so much more palatable for them to accept your offer. It's also a lot less vague and difficult for people to deal with than subject to suitable housing for seller. Those are very difficult and very undefined words that they seem like a great idea, but there's no definition to the time period. What if they never found suitable housing and now your buyer has put out appraisal funds or application fees? Those tend to be very vague. And if you actually have a defined period of time amount of money, at least you can get some traction early and really define what that relationship is going to be going forward.
Mhm.
What's really difficult is those terrible people that they just don't get along.
Yep.
Um, what oftentimes happens is your buyer wants to go in and do work, right? They don't want to sit there for 60 days, not have their painter go in, not have their contractor go in to do the wood floors, and so that's a really difficult time. And I usually tell people, listen, you can have people go in and give you quotes
Yeah.
but you're not going to have that work done. So it's a concession for the buyer because they really are putting off any work that they want to do for over 60 days if that's the period of time that they're dealing with. So
Mhm.
it's very nice for the seller, but it can be difficult on the buyer.
That's the first time I've heard that one there. So far in the transaction I have, it seems to be going smooth, but we haven't even closed yet.
Yeah.
So it's still fairly early in the process. So do you have like a standard agreement that you typically work with?
Yeah, I mean, it's usually a 2 to 3 page commitment for people. It's not a huge, I mean, typically it's reviewed at the same time as the purchase and sale because you then pull that out of the purchase and sale and you have that use and occupancy already signed. So we're not doing this at closing. There's a last minute renegotiation. It is sort of set and sealed as of the time that the purchase and sale is signed, so that you're not having to think about it and people aren't having to go back to attorneys at that point. Lenders probably don't love them. It's simply not
Yeah.
what they are considering they're giving a loan for. They're giving a loan for a primary residence. They expect the person is moving in, and there could be litigation with respect to it. Worst case scenario, people aren't getting along, things break,
Yeah.
people cannot agree. And it does keep people in each other's lives a lot longer. I mean, I know I tell
Mhm.
people, please don't independently reach out to the other side. Right? Let's not have an ongoing relationship. Let your broker do their job, let the attorneys do their job, but please don't create this lovely, you know, secondary conversation because it becomes confusing. And so
Right.
that can happen post closing when you have somebody living in the house that you've just purchased. And so it can get a little nebulous. It keeps the agents involved longer. It keeps the closing attorney who's holding the funds in longer. So it really does involve a lot of people signing up for a longer relationship than the typical closing.
So it sounds like typically what happens is the utilities are paid for. Are they read? Are the final readings done when the seller moves out, or are they
So
done at the closing?
it depends. So a municipality, so if you're in somewhere like a Georgetown, they have municipal electric, right? So you're going to get that final read
Yeah.
because it just has to happen for title purposes. So that
Hmm.
has to be on a CD, and then you cut, and then it moves into the buyer's name, but maybe the seller still retains responsibility for payment. In a national grid situation, you can just leave it open. You can leave it open until they change over. Depends on what the parties want to do, because national grid can't allow a new person to sign up until the old person comes off of their account, but it doesn't necessarily align with the property such that it creates a lien in the event of a closing. So if the national grid situation, you can go either way. They can either leave it open or they can cut it off, but we're not going to pay it off at closing in any event. In a municipality situation, it is going to close out, the new owner will take over, and then the defined party who's the obligor on that payment will then make the payment regardless of whose name it's in.
Now, what about final water readings?
Yeah,
Like
that's a
Andover,
little,
yeah,
yep. So you will do the final water, and then
at the closing,
essentially
right?
you'll do that at closing, you'll pay it off and be done. And then typically we just basically say that's going to either, figure that into the use and occupancy fee, so that we're not redoing a new final water for someone.
Hmm.
It's the usage use isn't that unless you have like, the pool with, and landscape and you're just using everything.
Sprinklers.
The cost just isn't going to be high enough to worry about doing another final water for that. So I usually would say to people, the buyer, consider that your obligation, and assume that into any sort of cost that you're going to associate with the use and occupancy for the seller.
And what have you seen, like, for example, oil? Do they wait until the use and occupancy is over?
So no, I would typically do a final and then again assume that into a cost on the use and occupancy. Um, Again, it depends on when you're closing. You're much higher concern during the winter, no concern during the summer. So if you know your house is a massive oil problem, and it's just going to cost you a lot of money, or the other negotiation is, listen, we won't do a final, or we won't do a proration on the oil. We'll give you what's left in the tank, but we'll just continue with that during our use and occupancy as well. And so if the seller sort of says, listen, I'm not going to look for a credit back for the oil, that can usually resolve pretty easily for the buyer as well.
Have you seen any kind of horror stories that have happened with this so far?
Just the one with the dishwasher, which was a nightmare. Yeah. And they had a roof issue as well. And it was, it wasn't necessarily because of the use that occupancy, but it made things more difficult for access purposes. And, it created bad feelings. So
what happened to the roof?
The roof they had an issue before and they knew about it, but then of course it restarted while they were still in residence. And it wasn't necessarily a new issue, but getting in there to deal with it. You're dealing with contract and plus COVID, but you're dealing with contractors, parties working at home. The new buyer isn't living there. Coordination was just very difficult for them. And while that's okay and can work, it's just very arduous for people if they're feeling, you always have a little buyer's remorse at times, right? You always have that buyer who goes, oh, maybe, maybe, maybe. And that can really bring it to the forefront. And you don't want them to have a bad taste in their mouth when they're still in a relationship with anyone. You don't ever want them to have a bad taste, but, that can tend to elongate that worry for them.
Yeah, that's a lot of the offers that we're seeing come across now have no home inspections.
Yes, which is super concerning. It's a 20 to 30 year commitment for most people. They aren't looking to move in 5 years necessarily. And I always tell people that I work with who are brokers, if your company you should have something, you should have your buyer sign off that you have recommended or advise them about an inspection and sign on the dotted line, protecting yourself, because you know them best, right? Attorneys come in at the end and we're often on the phone with them, but we don't have the same relationship with the clients, for good or for bad, as the brokers. You simply just put in so much more time than we do. And no one wants to be the person that has the finger pointed at them. And it's not fair, but when things go wrong, they point to the closest person, and you just want to be very, very conservative and careful about that, because I think everyone that I've had this week has come in without an inspection.
Yeah. I mean, we had a property last week that went under, and I mean, we did one inspection. I think that's the first inspection on one of my listings that we've had done in, I don't know how long.
Yeah.
And then we had another one that we were negotiating two houses last week, and the other one, there was 21 offers, and I think maybe two had a home inspection.
Yeah. And those are going to knock them right out of the park, right? Because
right.
Put those aside.
Right, exactly. So, and I know it's a little off topic here, but what are your thoughts on? I mean, is it legal for someone to have a home inspection on the seller's house without the seller's consent?
So that's why we usually strip that out of the P&S. They shouldn't. So you put your offer in, you have your.
This is before an offer.
Like, for example, I have a Danvers listing that just came on today, and I've gotten multiple showing requests for 30-minute time slots, which is kind of making me question, are they planning on showing up there with an inspector so that they don't need to write up an offer with the home inspection contingency?
Right. And that's possible. I don't think it's necessarily illegal, but what I always tell people is, do not ever open the inspection report, period. And people love to send them like, oh, there's a problem. And then you're on notice, right? The seller's on notice that there could be a material defect in the property and they have to disclose going forward. Absolutely not okay. And I think that's really a question of being very clear with people. Listen, you can come in, but we're not, it's 15 minutes, or you being present at the property. And again, with COVID, there's a lot more, distance between people, and you're not necessarily sitting at the property. But yeah, we have people go in with contractors. Oh, it's just somebody who wants to look at the floor. And it's their cousin who is really doing inspections in New Hampshire, and they're going through and kind of fiddling around. And it's just something where I think defining who can be in the property and for how long, and really forcing their feet to the fire before that happens.
Yeah.
It's a tough thing to control at times.
It is. And it's, you've got the brokers that are trying to do it right and ask you ahead of time for permission. And I can really appreciate that much more than I did. And then you have brokers that just go in and, but I'm not sure they're actually doing their clients a favor, because it puts such a bad taste in the seller's mouth that they almost kind of get blackballed before they put the offer in.
Yeah, if they get caught, no one wants to deal with them, right? So It's not like they're putting themselves in a good position. I mean, we have had people negotiate to, say, hey, to the seller, do you want to do a kind of an inspection ahead of time? As a seller, you go, no, not really. Depending on the type of house, if you have new construction and you're fairly sure everything's okay, that's one thing. If you've been living in the bungalow for 30 years and, we kind of know things are on their last legs, you're not going to want to, have that sort of exposure for your seller. And I think, as an agent, it's so much of your jobs are interaction and trust building between agents,
Right.
that to do something like that to another agent is really very destructive,
Mhm.
because this is not the only offer they're going to deal with you on.
Right.
I think it creates a very, very bad taste in your mouth.
Yeah, but this was the first time that I had seen that done like that. Usually, I did have somebody ask me, is it okay if we have an inspection? And, I already had a number of offers in, and the home inspection was crossed out. So, I mean, I leave it up to the seller. I don't answer for the seller. I say, look, this is what I'm being asked, and this is what we have for offers that I've sent you. And what are your thoughts on that? And it came back like, why should we let them in to do an inspection? We've already got offers with no inspection. So,
Yeah, that's absolutely correct. I mean, and a lot of times you'll see in a purchase and sale agreement, and one of the, in the initial drafts, access after purchase and sale and before closing, there's always a little inspection. You always have to
Right.
strip that out, because that has been waived. I don't care if it's an
Mhm.
inspection of paint colors. We can
Right.
put it in a different way. Inspection has been waived. And you really it's, not a way you want to be dealing with people in business.
Right. Exactly. So,
Oh.
go ahead, Mackenzie.
Something that we saw this past week too was that when some agents were submitting offers, they were writing in the additional terms that the inspection was waived, but they weren't actually crossing it out in the offer to purchase. So what exactly does that mean? Because typically if I'm waiving a home inspection for one of my buyers, I make sure to cross out the whole paragraph and then mention it in the additional terms as well.
Yeah, being abundantly clear is always better. I mean, everything should be in writing, and there's a reason there's a paragraph. Take the whole thing out. If you're the seller and you're accepting that offer, first thing I would do is crosshatch through that, and be very, very clear. There's no assumptions in real estate. There
Right.
can't be. There's a reason we need to have things in writing, and that everything has to be in writing for a transfer. And that's to leave it unclear is not doing anybody a service, including the buyer, right? You don't need the buyer to come in thinking one thing, because then you're just perpetuating a problem that's going to take 10 days to resolve, potentially, if they're under the impression that because they didn't, take that out, that's still, something that they can deal with. You're then, your buyer's out 10 days, your seller's upset, the brokers are unclear. I was, if it's unclear, literally draw a line through it. That is
Right.
not something we're ever going to quibble about.
So now, Mackenzie, do you have any more questions for Libby? We're kind of getting to the end of our program here.
I think that we, actually, I do have one more. So how do you guys determine the amount for the holdback and for the rent payment, like per month?
Sure.
I get that question a lot. Like,
Yeah. So as long as there's going to be one, right? So as long as everyone's speaking the same language and that there's going to be a concession for, the seller being able to stay there, I would typically base it on what the buyer's costs are to carry the property during that time period. So for instance, if they have a $1,200 a month mortgage payment and, that includes, taxes and insurance, for instance, I would say that's a very fair place to start and say, okay, you see the offer come in and you're going to negotiate the use and occupancy. You look to see how much is the mortgage, how much are they going to finance? It's $300,000. Even go with a high percentage rate, figure out what a monthly amount typically would be. And then I would back into the number that way. Use and occupancies they are really supposed to work effectively. They're not necessarily a punishment, right? So some people are like, well, how about $3,000 a month? That's nice, but it's that actually doesn't really get you across the finish line, because as a buyer, you want it to look good and you need to have a rationale behind it. And the rationale is, I can't move into the house that I'm paying $1,200 a month on. So minimally, if you do that, you're covering my costs. I want you to be able to stay, but I also can't afford to have, not taken residence for 60 days. So I think it's a good rationale to start with what the prospective cost is, unless they're doing a 10-year mortgage at $300,000 and their monthly rate is crazy. Base it on a conventional, and I think it's a fairly standard way to kind of first address that. If there are other items in play, super costs for them staying where they are, if they're, maybe you base it on the stay over rent that they're paying, if that's, a separate consideration or a higher consideration. If they're coming in as a cash buyer, that gets a little different. Then maybe look at, say, a 3-bedroom in the area that, what's an appropriate rental rate, and maybe slide it down a little bit to, as a buyer, and say, okay, well, I could get $3,000 a month for this house on a rental market, but I want this to look good. I want this to be a benefit to my offer. So I'm going to make it $2,000, even though I probably could get $3,000 if I was going on the open market.
Now,
Right,
what do you hold back in escrow?
So that's a good question. Depends on how long the use and occupancy is for. But for instance, say you have a 60-day, you have a monthly amount. I would always take that maybe 2.5 times that, and set it aside. Again, you kind of have to look at the people you're dealing with too. How close are they on their numbers? If the seller is selling and they don't have a mortgage and they've just got a lot of liquidity coming out of the closing, they're going to have a lot more negotiating room for that. If it's somebody who's really tight on their numbers and they're desperately staying because they don't have an alternative, you have to be careful about those numbers. But you also look at the punitive amount, right? If it's $300 a day, kick it out for 2 months and figure out, back into a number, $300 a day, call it for 2 months and back into the number that way too. And you really are looking at the worst case scenario there. And the hope is that never gets needed.
Do you have any more questions, Mackenzie? Any more thoughts?
No,
I don't. I think we went over everything.
Anything else you can think of, Libby?
No, I think the list of horribles has been sadly told. But, I think, I love people being strategic and creative with offers. I think it's so necessary in this environment. And I think you guys do a really good job of figuring out and communicating with the listing agent and figuring out what is it that the seller wants. That's really what you're looking for here. And I think that's super important. Having that dialogue is really key, and having that trust factor. So I think, I've only had a good experience, but for the one, and those happen. We try to prevent them and just be very upfront with the attorney and say, listen, here are the parameters, and now negotiate, because the more we know, the better we can do to help you and your client.
Right. Well, Libby, how do people get a hold of you if they would like to
Sure.
work with you? We love working with you, Libby.
Well, it's been a pleasure. So I can certainly provide information, but it's my email address is just my first name, Libby, which is not on the screen, sorry, but it's Libby at ebtangneylaw.com. So it's just my first initial, my last name, law.com. And my phone number is 978-607-0590. But I am in Salem. I'm certainly available, and it's been just wonderful to work in the Andover area. The attorneys up there are wonderful. The brokers have been great. And yeah,
You get that
really,
you get that Salem cheese shop over there.
oh, so good.
Oh,
So
love it.
come to Salem. Such great eating. It's a
I know.
problem.
My daughter lives in
Uh,
Beverly and we're down there all the time.
oh,
It's great. I love that
it's
Salem cheese shop.
yeah, I could sit in there forever and just kind of waft the smell.
Mhm.
But yeah, it's been great, and I'm right on 10 Federal Street, so we're right downtown. But I go where the clients are because it's most important that the clients be comfortable, especially during this time period. You want to make sure that they're comfortable signing, and that they're not put out. So I often come to Andover to do that.
Well, Libby, thank you so much for joining us
Pleasure.
today. I
Thank you so
greatly
much.
appreciate that. And we really look forward to doing business with you. And thank you so much for your
Same.
time. We appreciate it.
Thank you.
All right. Have a great
Pleasure.
day.
You too.